Dumelang, welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today is part 2 in relation to changing or challenging the decisions of the court. And as stated in part 1, I will be dealing with variation and rescission applications. But before we get started in today's video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. I'm going to be focusing on rescission and variation based on the rules of the High Court. There are various situations where a person will go to court to ask for an order or judgment to be rescinded or varied. The first one is where an order or judgment was erroneously sought or erroneously granted without notice to the parties. And an example would be where the parties didn't appear because they were never notified of the fact that their matter was coming up. Another situation that a person can use to rescind or vary a judgment or an order is where that judgment or an order is ambiguous, where it is not clear exactly what is being said in it, where there is a patent error or omission. For example, if the order or judgment says that the defendant is awarded 10,000 pula against the plaintiff, and yet the person who brought the matter to court is the plaintiff, the plaintiff can go back to court and seek a rescission or variation of the order because they would have been the ones to bring a matter seeking judgment in the amount of 10,000 and not the defendant. And it is clear in that situation that there was an error, a patent error in that order or judgment. And the other one is where there is a mistake that is common to all parties. An example is if a person brings a matter against person A. Let's say this plaintiff is suing person A for the return of their motor vehicle, for example. And person A continues with the matter and so on. And after judgment is given, it is then realized that no, person A was not the one that was supposed to be sued. It was supposed to be person B. Because that is a mistake that was common to both the plaintiff and person A as the defendant, then either party can bring a matter to have this order or judgment rescinded. Another situation is where an order or judgment was given in default because one of the parties didn't appear, or the matter is dismissed because the person who brought the matter was not able to appear on that specific day. If they come and bring an application for rescission, then they have to file an affidavit where they explain the situation that led to the default judgment being granted against them, as well as to explain that they are not simply trying to rescind this order or judgment just to delay the matter. They have to show that they have a very good defense against the matter that is being brought against them. And because this rescission and variation has to be brought by a way of an application, this application has to be served on all the parties that will be affected by the rescission or variation of the order or that have been affected by the judgment and so on. And the court must be satisfied before it rescinds or varies the order that everyone who is interested and will be affected has been served. Now, before we move on to the issue of variation of maintenance orders, I would like to put in our sponsor for a seminar coming up on the 12th of November. Have you been curious about the issue of the law and inheritance? We will be holding a seminar on the 12th of November 2022 where we will be talking about inheritance, talking about people that have never been married, people that are married in or out of community of property. We will be talking about inheritance, looking at children, and other family members such as parents. So be sure to send an email to the address given to book your spot, and it doesn't matter where you are. We have physical attendance and virtual attendance. Send an email to make further inquiries about virtual attendance. And I hope to see you there so that you can ask any questions that you might have on this issue of inheritance. Now back to our video. When we talk about variation of a maintenance order, it does not necessarily have to fall into the categories I gave before. The important thing is change of circumstance. And this is true where a maintenance or access order has been granted as part of a divorce. Remember, the court, once a decree absolute for divorce has been given, cannot rescind that divorce. However, a person can bring an application to vary the order where it deals with issues of maintenance and access. An example of where a person brings an application to vary a maintenance and access order is where a child lives with their father and the mother pays 500 pula as maintenance, as an example. And this mother gets to have visitation with the child every other weekend, on school holidays, and so on. If the mother's circumstance changes, for example, if she loses her job or she gets a lower paying job, she can bring an application before the court to reduce this maintenance. Similarly, if the mother's job improves and so on, then the father can bring an application to the court to vary the order to increase the maintenance that is being asked for, and state that, there's been a change of circumstance, and now as the years have gone by, things have gotten more expensive, but the child's mother's job has improved and they get more money, and therefore I'm asking for a larger or higher contribution towards maintenance. And maintenance orders can be varied at any time as long as there's a demonstration of this change of circumstance. The reason why it is important to serve people with the application for rescission or variation, no matter the reasons for such rescission or variation, is so that they can be given an opportunity to oppose that application if they want to, looking at various circumstances. I hope that you've gotten some insight into the issue of variation and rescissions of court orders. Please make sure to follow me on various social media platforms, Facebook, TikTok, Twitter, as Botswana Thinking Law, and make sure to like, share, and subscribe to this YouTube channel. Ring the notification bell so that every time I put up a new video, you get notified. And I will see you in my next video. Bye!